Greetings and welcome to the latest edition of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments like New Jersey to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing a report by Colin Eaton, writing for the Wall Street Journal, entitled Exxon Blasts Proxy Advisors for Conflict of Interest in a Fight Over Texas Move, referring, of course, to the redomestication of Exxon to Texas from the not-so-Garden State. Now, if you have been listening to Legal Bites, you know that, as I have reported, this move was ultimately approved. However, this presentation will delve deeper into the apparent conflicts of interest which unfolded behind the scenes. I will then conclude by explaining how small and medium-sized business owners can use the same laws to their advantage to relocate out of New Jersey or out of another jurisdiction to a new state. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. Now on to business. ExxonMobil has been incorporated in New Jersey since 1882, and in 2026, it asked its shareholders to move the legal home of the corporation, referred to as the corporation's domicile, to Texas. And 2 proxy advisory firms tried to stop it, ultimately unsuccessfully, as I mentioned earlier, but let's get into the details. Those firms are Institutional Shareholder Services, more commonly known as ISS, and Glass Lewis. Now, institutional investors pay them to recommend how to vote the shares they hold, and much of the institutional vote de facto follows that recommendation. Both ISS and Glass Lewis recommended against the move. Their stated reason was that it would eliminate investor protections established under New Jersey law. Exxon answered that it was adopting none of the elective provisions of the Texas Business Organizations Code that would otherwise weaken shareholder rights. On that record, the objection was not to what Exxon proposed to do, rather, it was to the state Exxon proposed to do it in. Exxon then bought full-page newspaper advertisements and made a different argument. It said it was not surprised the 2 dominant advisory firms opposed the move, but that it was surprised that neither firm disclosed its pending litigation against the Texas Attorney General under its own conflict of interest policy. Oops, they were caught. Both firms had sued the Office of Attorney General Ken Paxton over a 2025 Texas statute, Senate Bill 2337, which requires proxy advisors to disclose when a recommendation rests on non-financial considerations. They argued the statute violated the First Amendment and won preliminary injunctions against its enforcement. Glass Lewis responded that there is no conflict of interest, nothing to see here, move along, that its research on and reincorporation proposals is separate from the lawsuit, and that the lawsuit is public. Well, I think their response, or lack of response, as I would characterize it as, speaks for itself. Days before the shareholder meeting, Paxton sued ISS for misleading investors and said the firm was working to obstruct the Exxon move. The firm said the claims lack merit and that it would defend itself. typical lawyer boilerplate. Now, the opposition ran further than the advisors. The comptroller of New York City, who advises the City Police Pension Fund, urged investors to vote no and warned that shareholders would hold fewer protections in Texas, which is a blatant lie. Exxon's chief executive said the move protects the company from frivolous shareholder litigation, which is true if you actually bother to read the law, and that Texas understands the oil and gas industry. The shareholders ultimately approved the move. Now, Exxon is certainly not alone, as you have heard in earlier presentations. Tesla relocated, Dell relocated, several others have relocated, too many to list here. Review our earlier episodes if you are just getting started. Now, the lesson is not about the Lone Star State. The choice of domicile belongs to the owners of a company, and the people who advise against it are not always as disinterested as they would have you believe. Now, with this context in mind, redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax consequences, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial disruption, but only if you get it right the first time. That is why it is so important to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, including New Jersey, and for limited liability companies, partnerships, subchapter S entities, and subchapter C corporations. So if someone is telling you it can't be done, what they are really telling you is that they don't know how to do it. Now, foreign entity registration is simply not the same thing as redomestication because foreign entity registration, also referred to as foreign qualification, does not change the company's legal domicile. In fact, it does the opposite by keeping the entity in the former state indefinitely and merely adding a second layer of compliance and tax obligations in the destination jurisdiction. Meanwhile, a traditional merger, which is also not the same thing as redomestication, creates a new distinct entity in the destination state, may and often does require the issuance of a new federal employer identification number and can trigger serious tax consequences. Finally, dissolution should not enter the conversation at all because dissolution terminates the company. Dissolution is a going out of business maneuver, not a relocation mechanism. And to make matters worse, dissolution is often a taxable event and when performed inadvisedly can expose the owners of the company to unlimited personal, yes, you heard me correctly, personal, joint and several liability for the company's liabilities, known and unknown. That is because the so-called veil of liability protection no longer exists because the company no longer exists. So if you have a so-called professional suggesting dissolution as a relocation option, please seek better advice. Now, redomestication, when paired with the change of personal residency and that is a very important and, a reduction or outright cessation of business operations in that former state can reduce or even eliminate state tax exposure there for the entity and its owners. Don't take my word for it. Ask your CPA. If you get a blank stare from your CPA, well, it might be time to work with somebody more experienced. Now is the time to consider acting before the New Jersey State House considers changes to the law to hinder or even eliminate the avenue of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of New Jersey or out of another state, please use the link in the description for more information on this nuanced process and to schedule time for you and I to speak one on one about your specific scenario. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these topics, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.